You would help me.
Yeah, I'll bring it.
Where?
Okay. Yep.
Welcome, everybody. Today we're going to, I'm Mike Gravely. I'm from the Kenosha District Attorney's Office. I'm the elected district attorney here in Kenosha County. Today we're going to talk in great detail about the events that happened here in Kenosha on August 23rd, 2020. It's very important to me that I insist that this conversation be a complicated conversation, that it be a real conversation, not a simplistic one, and that we talk accurately and thoroughly about the law and the facts of this case. I want to thank Noble Ray, who is the neutral, independent use of force expert in this case, found for this case by the Attorney General of the state of Wisconsin. I want to thank him for the report that he prepared in this case and the conclusions regarding use of force and police training that he has offered us. And also because he is present today and he will have a chance to present those findings to all of you and then to be part of answering questions. I expect us to conclude at 5 today, and again, I expect my presentation and Chief Ray's to be lengthy, so I apologize in advance if there's not a lot of opportunity for questions. But I do feel that the occasion and the tragedy that happened on August 23rd is deserving of a lengthy discussion by both the prosecutor, myself, and by Noble Ray here today. Again, I want to speak to the tragedy of what happened. This was a tragedy first and foremost for Jacob Blake, who still suffers from grievous injuries. These are life-lasting injuries that he suffers from today. I had an opportunity to tell him what I was going to announce to all of you today in a phone call just a few minutes ago. And his update is that he is still on a daily basis suffering the injuries that he first suffered, of course, on August 23rd. This is a tragedy for those who love Jacob Blake. He is a father, a son, and a nephew. And I want to acknowledge and say that I really feel like the Blake family and Mr. Blake himself have tried to be real, truly positive forces in the community, asking the community to have peaceful but real dialogue about change that I think is necessary in this community, outlined by the issues exposed in this case. And so I thank them for their positive contributions, and certainly there is a tragedy here for them as well. I have thought several times and had a quick conversation with Mr. Blake today about his children who were in that vehicle. And I have thought, as I considered the evidence many times in these last few months, what the impact of his children, the seeing those gunshots would be in their futures. And so I was able to briefly speak to him about that today as well. Clearly, this has been a tragedy for this community. We have seen, based on the results of what happened in the aftermath, that there are persons in this community or outside the community, people who come here, whatever guise that is, that are capable of expressing their anger in these moments by burning things down. The challenge now, and part of what I hope to begin in my conversation today, is rather than burning things down, can moments of tragedy like this be an opportunity to build things? Are there times and circumstances that are tragic where communities in their healing process can begin to make themselves a better community that allows for all points of views and allows for all the parties, even those who feel so disenfranchised, to have a voice? And then I don't want to leave out the officers whose entire careers, in fact their whole lives, have been judged by a few seconds that they conducted themselves on these shifts, and to their families, because there's a tragedy there. They've clearly been impacted in the several months that this decision has been awaited. I want to speak briefly in apology to all the people in the Kenosha community who have suffered in any way from the fact that this date and time of this decision was kept a secret, although possibly the worst kept secret in the history of secrets. But certainly there are many people in this community who felt like their own sense of security or their economic security, their businesses, were impacted by the fact that no one set a particular date, a month in advance, etc., to announce this decision. And that was done deliberately because of security concerns. So the advice we were given is that we could not do that. And so again, I apologize to persons out there hearing this today who are justifiably angered that they were inconvenienced in those major ways because they were not able to be given advance notice. Today, there's a very narrow decision that must be made. And so I will be announcing today the question of whether the District Attorney's Office, in its professional judgment, feels that there is sufficient admissible evidence to convince a jury beyond a reasonable doubt that Officer Shesky or any of the other Kenosha officers shot Jacob Blake unlawfully or committed any other offense. That's the task. It's a narrow task today. It's a legal and professional task. But I want to say that I feel in many ways completely inadequate for this moment. I have never in my life had a moment where I had to contend with explicit or implicit bias based on my race. I have never had a moment in my whole life where I had to fear for my safety with either police officers or individuals in authority. And yet I have had conversations with people that I trust and admire who tell me they do have that life experience. So that is an authentic experience I do not have, and I do not bring to this decision today. Conversely, I have never been an individual who has left my family and gone to a shift at work knowing I could face armed persons who might try to end my life. And further knowing that in the course of my job, in facing those armed people who might try to end my life, I might not have the option to run away or to hide as any private citizen rationally would. And I know that to be an authentic experience, and that is not an authentic experience I bring to this decision today either. What I do bring to this decision is almost 3 decades as a prosecutor making charging decisions, which is what I'm being asked to do today. I have my entire professional life tried to keep this community safe. Tens of thousands of times I have looked at sets of facts and had to make a decision whether there were sufficient facts that fit the law that would allow the prosecutors, including myself, to be able to prove a case to a jury beyond a reasonable doubt. I have personally taken more than 250 cases to jury trial. So I think I can confidently say where I do have authentic experience and expertise is in an ability to talk to a community and to all of you about what evidence would be admissible in a jury trial if anyone was charged, and whether that evidence would be sufficient to get a conviction. I also have a complete and absolute commitment that that charging decision must be made independent of outside forces or the political winds that swirl about in this year and this era that we're in. It's an absolute commitment I have. And I hope that in these troubled times that our community, and maybe America, has perhaps rarely been in greater need of a neutral, professional person to referee these disputes in the criminal justice system. And so I provide that professional judgment, and I bring that to the evidence today. So, the first thing I want to do is talk about a statute in Wisconsin designed specifically for the investigative and charging process for fatal police shootings. Thankfully, Jacob Blake is alive, right? He is grievously injured, but he is not deceased. But this statute is still an excellent guide to allow us our best chance at an independent, investigative, and charging decision. So what is the statute? If it's our guidepost, where does it take us? The statute first requires an investigation by an independent agency. And in this case, the Department of Justice, the Division of Criminal Investigations, I'm going to call them DCI, got to the scene as soon as they could. They secured the scene, and they immediately began to be the investigative agency. Ultimately, that responsibility was shared with the FBI in some small amount when they needed additional persons. The statute requires that when that investigation is completed, in as timely, expeditious a manner as possible, it goes to the district attorney in the county where the shooting occurred. Of course, that is, in this case, Kenosha. And in this situation, an exhaustive investigation was done. There's more than 40 hours of squad video. There's hundreds of pages of electronic information. There are almost 200 separate law enforcement reports and almost 1,500 individual pages of police reports. So this was clearly a dramatically exhaustive investigation. And was it expeditious? They got it to Noble Ray, the independent use of force expert on this case, by, I believe, October 8, 2020, and ultimately to the district attorney's office as well. Then the statute requires that the district attorney, the elected district attorney in that county, must determine if there's a basis to prosecute any of the involved law enforcement. And it is my decision now that I announce today before you that no Kenosha law enforcement officer in this case will be charged with any criminal offense based on the facts and the laws as I will describe them to you now. So it is our decision that no charge will be filed. I'm going to also tell you, just because I think it is important, that no charge will be filed against Jacob Blake in regards to this incident as well. For many of the same reasons, in terms of an overall discussion about this case, that is not something that the District Attorney's Office intends to pursue. Now, if the District Attorney's Office does not file charges, if that does not happen, then immediate transparency has to take place. And so what has to happen is, first, the DCI website will by 5 o'clock today have available their complete investigative file. And second, the District Attorney's Office, which is not only going to put this PowerPoint, which is an abbreviated version of our report, will be publicly available, but we have a more lengthy written report that will also be available to the public. Both of those things will be available on a website that will be identified in a final slide here, and they'll both be available at 5 o'clock today. In addition, Noble Ray, the independent use of force expert, has drafted a report with all of his findings. That also will be available at that time. So now I intend to talk about what steps were taken specifically by the DA's office to prepare for this investigation, and then finally what our conclusions are about the law and the evidence in this case. As soon as I saw the video and shared the same emotional reactions that I think so many people in the public did in my first viewing of the circumstances of the video that certainly went viral immediately, I knew at that time that we needed to do the most independent charging decision and investigative process that could possibly be done. And at the very first moment I learned that, I called on the U.S. Attorney's Office to do a parallel civil rights investigation that would be a separate investigation and conclusion and findings from our own. Now, the U.S. Attorney's Office has civil rights specialists who prosecute and make charging decisions about officers and any misconduct. So they have specialists who do that. They work out of their Washington, D.C. office. They did agree that they would do an investigation. I know that is going on, and I invite you to contact that office to find out what their status is. I know they are attempting to get to a point where they're able to make charging decisions as well. Kenosha deserves a second legal opinion other than my own. I'm confident about the things I'm talking about today, but I believe that the healing process begins or is improved by an opportunity for members of the public to see other prosecuting agencies make decisions, even though their laws are somewhat and slightly different. The other thing I did, and I think this is an unprecedented thing in the state of Wisconsin. I don't think this has ever been done before. I asked the Wisconsin Attorney General to select for this particular case a use of force expert who I had nothing to do with hiring. So I asked them to find someone so that there would be a truly and completely independent expert on issues of police training and on issues of whether the use of force in this case was reasonable. And the way I did that was I asked them to select the person without me having any input. And what the Attorney General did was he asked Noble Ray, who's with me today, who accepted. And I knew Noble Ray's name. I knew him as a national and state spokesperson for police reform and talking about bias in policing, and a person who had spent, after a long career at the Madison Police Department, his second career was trying to be a voice on those issues on a national level. When I first had my contact with Noble Ray, had never spoken to him in my life, had never met him in person in my life until after the selection was made. My first conversation with him was about how I wanted in no way to influence the decision he came to about the matters that mattered in this case. And I told him, no matter what you conclude, we're going to publish that. That will be an independently formed opinion. I won't have any influence, and you will be allowed to put anything you want in there, and I will invite you to offer any opinions you feel are appropriate. And you'll hear those shared by Noble Ray today, and you'll know that as you hear those, that those Those are facts and findings from an expert who the district attorney, in this case myself, did not influence. I also took pains to stay out of any contacts with any family members, any civil attorneys, any of the people who someone might think might have an ability to influence this decision. I purposely avoided those individuals. My first conversation with Jacob Blake was today, just minutes before this press conference, and I have still not spoken to any of the officers impacted in this case. Okay, so that is the legal status of the investigation. I now want to talk specifically about the law of self-defense. I do that because my laser focus throughout this presentation is going to be, if one was to charge any officer in this case, what would be the laws that govern that case? What would a jury trial look like? Because if you do not have a case you can prove beyond a reasonable doubt, as you're going to hear me talk about, then you're ethically obligated not to charge such a case. And in my belief is that this is not a case where there would be any dispute about any of the factual circumstances of this case, except for one piece of the law, and that is self-defense. Remember, these are police officers who are uniformed officers. They're called to the scene on a designated domestic abuse call. When they get there, they know there is an arrest warrant for Jacob Blake, and they take actions at that time. And the question, really the only issue in this case, would be, do they have a right to the privilege of self-defense? So, this law I would summarize as follows. The question to a jury would be, did Officer Shesky reasonably believe that the shooting at Jacob Blake was necessary to prevent being stabbed by him, or necessary to prevent someone else from being in imminent danger of death or great bodily harm? Okay, that's the simple way of talking about it. What is reasonable belief? Okay, is it what you and I would think at our computer screen or in our living room? Well, the statute says reasonable belief is actually from the standpoint of Officer Shesky at the time of the shooting. So the jury is instructed that the reasonable belief idea is from the shoes of Officer Shesky when he makes his decision to fire the firearm. When we talk about police officers, courts have had to weigh in on this idea before. The U.S. Supreme Court, in the case I'm citing here, 1989, has talked about the very specific circumstances for officers, that they're in tense, uncertain situations, and that a jury would essentially be instructed that they cannot use 20/20 hindsight, that they have to be talking about what the decision would reasonably be from an officer in the shoes of Officer Shesky with the information and training available at that moment. I think it is quite common for persons to think that have mistakes in their belief about the burden of proof for for self-defense. I've heard a number of people talk to me about this case, and they say, well, let the officers claim self-defense. They'd have to prove that. And the reality is that's just not the case. In Wisconsin, and I believe this is law throughout the country, but it's certainly in Wisconsin, when there is enough information to raise self-defense, the burden of proof is on the state. It's on the prosecutor to disprove self-defense. So we would have to disprove the clear expression of these officers that they had to fire a weapon to defend themselves. Have to disprove that negative. The burden of proof is on the state in that situation. So I've told you that I do not believe the state, and we're going to go into some of the facts in detail in a minute, would be able to prove that the privilege of self-defense is not available, is not a defense in this case. And if that's true, then ethical considerations must determine what our next course is. So I want to talk briefly about the rest of what I have heard from the public in the sense of those individuals who have demanded or called for charges in this case. There's been a group of people who have said, you need to charge these officers because it will send a clear message to all officers everywhere about how they need to police in future. I call that the send a message charging decision. There's been a number of well-meaning voices who have said, you must charge this case to advance the causes of racial equity and to strike a blow forward in the idea that the criminal justice system is racist and expose the bias. And I call that the charge the case to advance a righteous cause. And then there's been the deeply human element, where people have said to me, Jacob Blake is a human being, his family has really suffered, and so you should charge this case so that he can heal through a jury trial, and so that his family will begin to heal through that process as well. I just need to be clear, all three of those bases are not ethically appropriate or possible bases to charge a criminal case in Wisconsin if you do not believe you can defeat the privilege of self-defense beyond a reasonable doubt. There's a case, Thompson v. State. State Supreme Court, almost 50 years ago, told us as prosecutors it's an abuse of discretion to charge if the evidence is clearly insufficient to support a conviction, meaning you have to have a confidence you can prove that case beyond a reasonable doubt. Okay, so why have I taken so much of your time and complicated this conversation with all this stuff about what the law is and what the ethics are? Okay, why is that? You know, most of you are here to hear the facts, right? What are the blockbuster new facts that I have to talk about? Well, I've done that because I again want to emphasize to you that this case has to be laser focused on what a jury trial would look like. Everybody has seen the video. And so from their perspective, they have tried this case at their computer screen or in their living room. As a professional, I am called upon to talk about how to try this case in a real jury room, in a real courtroom. What is the admissible evidence? What would be beyond a reasonable doubt? And so that's going to be the rest of the focus here. What it means is that this case is really all about self-defense, and can it be proven that it does not exist? It is really evidence about the perspective of Officer Shesky. What is his knowledge at each moment? And what does a reasonable officer do at each decision point? Those would be the things that would be primary. And almost none of those things are answered by the deeply disturbing video that we have all seen. Almost none of those things are answered. I divide the witnesses in this case into three categories. Certainly the cops would all be witnesses. All three of these officers. There is general disagreement by the officers who were right there that this was a self-defense situation. They described the same motion that I'm going to go to in detail where Officer Shesky felt he was about to be stabbed. So it's crucial what they knew at every stage, how those officers perceived it, and then also crucial is there any other evidence that disproves, that shows that officers are lying about the things they offered to investigators. And by the way, the officers were completely cooperative in this investigation. Jacob Blake would certainly be another witness in this case. He also was completely cooperative in this investigation. And he, if you prosecuted this case, would be the key witness, right? He would be the star witness of any prosecution case if you even contemplate having a jury trial where you charge and convict Officer Shesky or any other officer. So, focusing on Jacob Blake as the star witness, where are the areas where he and the officers agree? Where do he and those officers disagree? And if he disagrees with the officers, is Jacob Blake a credible witness in those areas? And that we're going to talk about in a second. And then finally, the other civilians, and I kind of put all of us in that same category because we are sort of eyewitnesses as well, right? Because we've seen a video where we also have seen a snap, a few seconds of what occurred in this case. I believe that those civilians who were on the scene would also testify. They would be part of a trial, of course. But again, they do not testify to things that are really in dispute. And so I believe those civilians would be more defined by what they don't know, by the things they are not aware of, than the things they do know. And that when a jury considered this case, their importance would diminish because of the requirements of the statutes. Here are the four things I want you to consider as I talk about the evidence. Number one, is this a domestic abuse case? Okay, if it is a domestic abuse case, are there certain considerations and priorities that officers need to incorporate in what they do? Number 2, was Jacob Blake armed? And if he was armed, what does that have to say about officers' decisions for self-defense? Number 3, what does any physical evidence tell us? For instance, can we talk a little bit about entrance wounds into the body of Jacob Blake today and whether those have significance in supporting or in some way disproving any story that officers would have about being on the verge of being stabbed at the point that shots are fired? What about the taser evidence? Is there evidence of tasing that occurred in this case? And then, what does our independent use of force expert conclude is reasonable? What does he say that a reasonable officer would do at each decision point? And I'm going to submit to you right now, when a jury heard and thought about this case, when they hear an independently appointed use of force expert with the long credibility and expertise of this expert that you have before you today, when they hear that he would be testifying that each decision by the officers in this case are reasonable by police officers, are appropriate and reasonable uses of force, that would be decisive to a jury in determining whether the privilege of self-defense could ever be defeated beyond a reasonable doubt. Okay, so with that I want to go through the evidence in some detail. First of all, what is the evidence about why police went to the scene? Well, we know on August 23rd they were called by LaQuisha Booker. LaQuisha Booker called the police. She reported that Jacob Blake would not give her back the keys to her rental vehicle, and she was afraid he was going to take that vehicle and crash it. She reported he had done that before. So now police know there's a vehicle in dispute. Jacob Blake already has the keys, and the concern is, will he crash that vehicle in an effort to leave? And so we're going to play that 911 call now, so you will hear that.
August 23, 2020, 17:10:35.
Fine, I'm willing to take that risk. Yes, I need an officer to 2805 4U Street, Unit D.
280540 Street, letter D as in David?
Yep, letter D as in David. Jacob Blake is here, and he has the keys to a rental that I purchased that I need to take back, and he's not trying to release it. And on top of that, he's not supposed to be here. Today is his son's birthday, so I allowed him to spend a couple hours with him, but he's not giving me the keys to this rental. And that's all I'm asking for. I never would have called you guys. I promise you I tried to keep from calling you guys. He's crashed numerous of my vehicles in the past, and I literally just bought one, like yesterday. And so just because he heard some false information, he's not willing to give me the keys to this car that doesn't even belong to me. Me and my sisters just saw him skirt off in it and turn around and come back. So I need you guys to come and I need these keys.
Okay, what is your name?
My name is LaQuisha Booker. Go ahead and tell the girls that. Go ahead and tell them that. Do not put your shoes on. The police are on their way here. Yes, it is. Do not put your shoes on, Israel. Go back to prison. You didn't even want to go outside.
Is Jacob there right now?
Yes, and he's trying to kiss his kid so he can hurry up and leave. He was here just talking all types of crazy, and now he's walking off now. Now he's getting ready to leave. Well, let me get the license plate.
Okay, and is he white, black, Hispanic?
Hold on, let me get the license plate number. He's kissing the rest of his kids. It's IVJ 935.
I as in Ida, Z as in Zebra, J as in John?
No, IVJ 935. Good luck.
V as in Victor?
Yeah, V as in Victor.
Okay.
And he's probably about to go crashing. He's pulling off right now. IVJ 935.
What state is it out of?
Shut the fuck up, bitch.
So that was the information provided to 911. The key question then, as I said, the focus is, what do officers know at every moment they make any substantive decisions in this case. Based on that 911 call, Officers Shesky, Moronic, and Arenas are dispatched to the scene for a family trouble call. That's a code for domestic abuse, involving a domestic dispute over car keys. Dispatch also told the responding officers Blake has a felony arrest warrant for domestic violence offenses and sexual assault. And so you'll hear that dispatch recording. You'll know exactly what the officers were told as they were headed towards the scene.
August 23, 2020, 17, 11:27.
Clear 618-707, family trouble.
618. 707.
618-707, 2805 40th Street, 28054 Street. Complainant says Jacob Blake isn't supposed to be there, and he took the complainant's keys and is refusing to get them back.
707.
Heckler 618-707, just for 43. We have a alert at this address for 99 for that subject.
707.
This is what comes up on the squad computer. So what you're seeing now is a picture of what Officer Shesky, who's in the passenger seat. Officer Moronic is really a brand new officer. She's driving. Shesky's able to operate the squad computer as they proceed. And this is what is on there, including that warrant information. As you heard, they heard that that warrant is linked to the same address. Again, another sign to officers who do not have complete information available that this is the place where the sexual assault and domestic abuse occurred that Jacob Blake has a warrant for. That's the warrant. It's a felony warrant for his arrest. So, that's the evidence that they have as they proceed in the squad car. You'll hear that in a moment that Officer Shesky operates the squad computer and gets a little more information about the warrant as they are driving to the scene. What other information do officers collect before any force or any action is done by officers in this case? So they arrive at the scene. Officers Moronic, Shesky, and Arenas all gather and head towards where LaQuisha Booker and Jacob Blake are located at this apartment building. And Officer Shesky sees Blake putting a child in the disputed vehicle. So now Officer Shesky has the added information that this vehicle that he believes Jacob Blake has keys for, that he knows is in dispute, now has a kid that's been included in the mix in that vehicle. Officer Shesky hears LaQuisha Booker yell, "It's him, it's him. He has my keys, it's my car, it's registered to me." And Shesky indicates one of the few conversations he has with Jacob Blake, one of the very few words that are exchanged between them, is Blake declaring his intention. I'm taking the kid and I'm taking the car. Officer Moronic hears something similar from LaQuisha Booker. And for anyone who would doubt that the officers are truthful about any of their reporting, certainly there is a civilian witness who also says she hears LaQuisha Booker yell to the police, here he is, he's trying to take my kids and take my car. So I'm going to suggest to you that the information you've heard so far is clearly, to any officer who hears it, a domestic abuse scenario that is there for them to reference and think about in terms of the considerations they must now make. And this slide really encapsulates all the reasons that I think this is a domestic abuse case, and clearly that's how it would be presented to a jury in thinking about what police officers are thinking about this case at the time. Now, I don't know if that's been out in the public. I don't know if any public take on the Jacob Blake shooting has been, oh well, wait a second, let's consider how officers have to think about domestic abuse. And so there may be persons out there in the public who would be deeply skeptical of that. They would say, you know what, What this sounds like so far is a guy who's trying to go somewhere with his kids and there's some argument over keys. That doesn't sound like domestic abuse to me. You haven't said anything about violence, for instance. And only for that reason do I believe this slide that's coming now about prior contacts between Jacob Blake and LaQuisha Booker on the issue of domestic abuse. It is only relevant for that purpose I just described. For anyone out there who says, you haven't in any way shown me that there's anything real about domestic abuse here, for those persons, I suggest to you that a pattern is very clear. Now let me be fair. Let me be absolutely fair here. No officer involved in this call knew about these contacts. So this is not something that would come up in a trial, okay? This is not something that anyone out there in the public could consider to just say, well, that means what he's saying is Jacob Blake's a bad guy, therefore, this is a different case. All I'm suggesting to you is that because many of the pieces of controlling behavior in these cases are about Jacob Blake seizing the keys or the car of LaQuisha Booker, and that there are instances of violence in some of these other cases, and that this is a pattern of behavior that the police have been involved in many times, that this really is an actual domestic abuse scenario played out one more time, unfortunately, on August 23rd. Controlling behavior is Jacob Blake, evidently hearing news he doesn't want to hear, and so deciding, now I'm going to take the kids, now I'm going to take the car. And LaQuisha Booker, powerless in that situation, going to the only place she believes that she will be able to get support, and that is law enforcement, to try to stop that stuff from happening. Okay, so that's what these contacts are about. One of these contacts, the one that's the last one on the list, dated May 3rd, is the warrant case, is the case that is the warrant for his arrest. In that case, a LaQuisha Booker, a distraught LaQuisha Booker, reports to police that Jacob Blake invaded her home, sexually assaulted her in a place he wasn't supposed to be, domestic violence type scenario, and took her car in that incident. That is the felony sexual assault, domestic violence case that he had a warrant out for on August 23rd. Again, it involves her car and that kind of controlling behavior. Just to further talk about domestic violence, in case you say, well, you know what, those all look like old offenses. How do I know that this modern stuff is, this recent stuff is domestic violence? Well, this is a text from Jacob Blake to LaQuisha regarding that May 3rd incident, where he's texting her, same pattern we see so often in the Kenosha District Attorney's Office in domestic abuse charges. Tell him you don't remember what you said and that you'd like to drop charges. So it's the same domestic abuse patterns that are so concerning, that are so difficult in terms of safety of the individuals who are suffering as victims being played out in this case. All right, why have I spent all this time on this? Okay, so, domestic abuse is a part of this. What possible reason would there be to spend this many minutes on it? And it's really because I want to be clear that officers, these are common calls for officers, and there are factors and things they have to consider that we as civilians probably don't consider every day, and that officers maybe don't even consider on other types of calls. And so it's about the fact that there's unpredictable anger that happens even in front of officers in circumstances that don't necessarily happen in non-domestic calls. And that controlling behavior, things like making sure that, I'm going to take your keys, I'm going to take your kids, that those things might be things that have to be looked out for. And then again and again, the fact that children can be pawns in the middle of these situations, that people who in no way want to harm their own children can sometimes endanger their children acting out the domestic abuse scenarios. Police are aware of all of those things, and those are all things that have to be priorities in their consideration of these type of calls. All right, I mentioned to you that Officer Shesky could see there was a warrant. That's the other large factor in this case. Here's a copy of the warrant that he would have been able, that is the cover sheet of that warrant. And I brought the policy of the Kenosha Police Department because it's so important that you understand. And I think that it's possible that Noble Ray will speak to this. Officer Shesky and these officers do not have discretion on something like a felony assaultive warrant like this. When they come across Jacob Blake, they must attempt to arrest him. They don't have other options. They can't say, that guy seems like he's going to fight with me, I'm not going to arrest him. There is not discretion in this regard. All right, so sure enough, there is resisting behavior. All right, that is clearly a large portion of this case, and I'm not sure any of that is really displayed on the video that we have all seen in any real way. But there are many commands disobeyed, and that's not only talked about by all the officers, but that's admitted by Jacob Blake in his statements, and there are a number of civilians who talk about that as well. And there are multiple ways that officers try to bring Jacob Blake into custody. Again, none of those, I think, visible in any of the videos. They try to direct him to the ground. They try to multiple officers try to grab his arms and secure him so he can be cuffed. He admits at one point, officers were trying to handcuff me, but I was able to get up. There's a time where he's down on the ground. I think we'll show you a video in a second that's enhanced, where a really close viewing of it shows Jacob Blake is on top of someone who has to be Officer Shesky, based on everyone else. And Officer Shesky says, I was on top of him, and then he was on top of me as we were grappling for me trying to get him under arrest. Most importantly, he was tased twice using remote kind of tasers and once with a direct strike with the taser. So I'm going to suggest to you 3 attempts were made to tase Jacob Blake to get him in compliance. There's the refuse of tasers all over the ground at different locations in this case when the scene is explored by DCI. And both Officer Moronic, but most importantly Officer Shesky, who's an officer who's been around for a few years, say they have never seen a defendant before who had as little impact by tasers as Jacob Blake did. And so that was certainly a factor in terms of the use of force options that were exercised in this case. Very important, Jacob Blake, while actively resisting, arms himself with a knife. I continue to hear, I think I heard at the rally last night, the vigil, where someone again said he was unarmed. It is absolutely incontrovertible that Jacob Blake was armed with a knife during this encounter. Uncontrovertible. Most uncontrovertible because Jacob Blake, in all of the times he spoke to DCI, admits he possessed a knife. Even tells us at different times he had the knife in different hands at different times. So he arms himself with a knife and refuses to drop that knife. And I know that knife is not easily visible in the video, but we're going to show it to you in a minute. So
you are broken, bitch! This bitch is broken! Mom, get back! Mom! 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 You have to get back!
So there's a lot of that video that is on the other side of the vehicle, as many of you saw. And again, that's an enhanced video, but it's unsteadily handled. Obviously, the person very nervous because of the traumatic events occurring as they videoed. But it does show a moment where Jacob Blake is on top of somebody who has to be Officer Shesky and shows at least a glimpse of the struggle that otherwise is not captured on video. Okay, so here's the beginning of much of the video that all of you have seen. Okay, so this is Jacob Blake as he begins to circle around the car. Officers are now keeping their distance. They're at gunpoint. And that's because officers have told us at DCI that they all, at that point, had seen him with a knife. And so they are keeping their distance in accordance with their training. And I believe Noble Ray will talk about that briefly with you as well. So at this point, I don't think you can see the knife. He walks around the vehicle, and you may have seen it there. This is an enhanced video, DCI doing the maximum they can do. There's a glimpse of the knife. The far left is that knife in his hand. Jacob Blake admits that. Jacob Blake admits to DCI that he had a knife in his hand, and that's what that is. It's not a cell phone. It's nothing else. He admits it. The knife itself is pictured there. It's a razor blade type knife. And then we had DCI, a analyst, take the shape of the knife and the size and match it to the picture to see if in fact it fit size and shape, and in fact it is a match. So we say with confidence, based on Blake's admission, based on all the officers saying it, and this video evidence, he clearly is armed with a knife as he walks around and approaches the driver's door. Okay? Clearly armed with a knife in that situation. All the discussion that he's unarmed contradicts even what he himself has said multiple times to investigators. Officers also yell, and citizen witnesses hear this, drop the knife. Under what circumstance would they be so specific unless it was a knife that they saw? I'm going to have you briefly listen to that enhanced audio. All of those things lead the investigators, lead myself, lead Noble Ray to say incontrovertible evidence, that he's armed with a knife in this situation. So what happens next? So Officer Shesky, again, confronted with the information we know so far, has additional decisions to make at the point we just left that video. Officer Shesky knows that an armed man with a felony warrant who has just forcefully resisted arrest appears to be about to flee in a vehicle that is a disputed vehicle, and there's at least one child in the back. Those are all facts that Officer Shesky has in the context of a domestic abuse case at the point he has to decide what to do next. And at that moment, Officer Shesky decides to re-engage. Up till now, officers have distanced themselves because a knife is possessed by Jacob Blake. So the question is, should an officer re-engage? Should he put himself back in harm's way by going and getting close again to an individual who is armed with a knife? Officer Shesky decides to do that. He grabs the t-shirt of Jacob Blake. Why does he do that? Well, he tells us that he did that because now the approach and entry is into the vehicle. Officer Shesky says, and I'm quoting or trying my best to quote him, "I don't know what he's going to do. Is he going to hurt the child? Is he going to take off in the vehicle? Are we going to be in a vehicle pursuit with a kid in the car? Will he hold the child hostage?" All of these things are things he is considering. They're running through his mind when he puts himself in harm's way and grabs the t-shirt of Jacob Blake. At that same time, let me just say, first of all, a use of force expert, Noble Ray, finds that decision to re-engage based on the factors that Shesky cited in my quote. Use of force expert Noble Ray has made the finding that was a reasonable decision to re-engage at that time. Obviously, risking at that point that there'd be further confrontation and the potential for harm. So, this is the moment in this picture you're going to see now. This is the moment where Officer Shesky decides, I've got to re-engage. At this same time, Jacob Blake tells investigators, I have switched the knife, which was in my left hand, and I have moved it to my right hand, because he opens the door with his left hand. So now we know the knife has moved to his right hand per what he says to DCI, and also the fact that this door is opened with the left hand. This is the moment where Officer Shesky makes a decision. I can't let him get in that car without being back in harm's way. This next picture is what happens next, right? And again, you've all seen this in the video. Both Officer Shesky and Officer Arenas report what happened next was Jacob Blake twisted his body, moving his right hand with the knife towards Officer Shesky. So and they demonstrate this, so they say what he does is he takes, again the knife is now in his right hand, and he goes under his left, and makes this kind of movement. So he switches his torso back towards Officer Shesky. Both officers say that occurred. So Officer Shesky is the one who's got the t-shirt. Obviously, he's in a perfect position to observe that. Officer Arenas is looking through the car window. He's also in a perfect position to observe that. Okay? Both of them say that's what happened. Unfortunately, when we view the video, Officer Arenas and that car door are in our way and don't allow us to see what happens to the rest of the body of Jacob Blake in this case. So I'd submit to you, here's where the video fails us, because it doesn't provide us any information or ability to take a look at whether that twist of the torso occurs. What we do know is that there are two civilian witnesses who also say they see a movement that I think any defense attorney for these officers would certainly argue is consistent with what the officers see. Okay? Why is this important? Because then this is not just officers saying this has occurred. This is other civilians on the scene who, based on their vantage point, are also able to add this perspective. A witness, DC, who indicates he has socialized before with Jacob Blake. He is on friendly relations with Jacob Blake. Says he saw Jacob Blake trying to get in the car. He saw Jacob Blake ignoring officers' commands. And ultimately, he saw Jacob Blake, what he says is twist his torso toward the officer from right to left, and then he heard the shots. He describes that twisting of the torso motion as sudden and rapid. And he's down the street, again at a vantage point that is less obscure than our video in terms of the doorway or the officer. There's also a witness right across the street, A.H. She says she sees Jacob Blake walking very fast around the street side of the car. He opens the car door. The police officer was behind him, and the police officer pulled at Jacob Blake's shirt. She says Jacob Blake then turned slightly, and the police officer started shooting. There's a picture here where we have an arrow to where she's located. Remember, this shooting occurs over on the driver's side of this vehicle, so I suggest your vantage point is a very good one. And clearly a defense attorney defending officers in this case and talking about the privilege of self-defense would have these civilian witnesses as key witnesses in their case. Now, there are other witnesses in this case, right? There's a number of other eyewitnesses. And again, I suggested that those witnesses are very similar to us. We saw the video, so we've seen snippets of what happened, but there's also things when we watched the video that we did not know. And I shared that experience with all of you. They were witnesses who were appalled by what they saw based on what information they had, and of course they didn't know what officers knew. So here's the type of things they didn't know, those other witnesses. They didn't know that this was in the context of a domestic dispute, and that might be something officers would have to factor in. They didn't know there was a felony arrest warrant. They didn't know that Jacob Blake was armed with a knife, though you now know that. We didn't know that when watching the video the first time. They didn't know there was no permission to operate that car. And some of them didn't know that there was a child in the car. So again, I would suggest to you, many of the witnesses in this case would be very clearly defined by the things they don't know and that really matter in terms of the privilege of self-defense. So I showed you what the motion was that the officers described, right? That move with with that right hand in a stabbing motion with the knife. By the way, the picture of the knife that was in the center picture in that slide was the picture taken from the driver's side floorboard. And that knife, as you saw, was open at the blade, right? So that's an open-bladed knife that was found exactly at this scene on the floorboard of that vehicle. All right. So I've described to you that both officers described this motion. From my perspective, another valuable piece of information in terms of whether the defense or privilege of self-defense is available is that Officer Arenas offers to DCI that from his vantage point that I showed you right at the car window, he also felt that it was necessary to fire to be able to save Officer Shesky from being stabbed. He offers to DCI didn't have to do this, but does say, I would have fired my gun as well had I had a ability in open shot because of exactly what I saw, thinking that Officer Shesky was a mere couple of feet away from being stabbed in that situation. Now, a couple things matter to me. Officer Shesky says, we were all aware that Jacob Blake was armed with that knife. We separated away from him. Officer Shesky says, I never felt it was appropriate to shoot my firearm just because he displayed that weapon. Officer Shesky does not say, I felt it was appropriate to shoot my firearm because he was about to flee in a vehicle. He doesn't say any of those things. He says the only time, the first time I felt it was appropriate to fire my firearm is the only time Jacob Blake showed any offensive intent. And that's when he made that motion where he was bringing his hand over towards me to stab me with the firearm. Officer Shesky shoots Jacob Blake 7 times. Okay, now this has been thoroughly discussed. That's a fact that's certainly known to the media. What the media may not know, and again, I've heard the narrative many, many times over the last few months where people say Jacob Blake was shot in the back 7 times. What we did was we went to Brian Peterson, who is the medical examiner in Milwaukee. So DCI went to him. They had him look at the medical reports and the x-rays. Quite appropriately, the ER doctors in this case were not prioritizing where entry wounds or exit wounds were because they were trying to patch up and do the fabulous job of saving Jacob Blake's life, right? So we asked an expert to come in who usually looks at cases, obviously, when people are deceased, right, a medical examiner. And we asked him to weigh in. And the opinion he has offered is that 4 of the wounds are to Jacob Blake's back, but 3 wounds are to Jacob Blake's left side. 3 of the entrance wounds are to Jacob Blake's left side. Okay, so again, Officer Shesky fired 7 times. It is absolutely appropriate for the public and any of us to consider, well, is that 7 shots excessive? Is that too many shots? And here's where Noble Ray again offers his expertise. He went into some detail in his report, and I believe we'll talk a little bit today about why 7 shots would happen and why that is within what he would consider a reasonable range of shots. Most importantly, Officer Shesky says, I continued to fire until Jacob Blake dropped the knife because I am trained to fire until the threat stops. So here's what happens, according to the officers. What happens is that Jacob Blake makes this motion, okay? He's fired on, and we know that Jacob Blake ultimately ends up seated in the driver's seat of the vehicle. We also know that his right hand has the knife and that it is dropped on the driver's side floorboard. So if you think about the defense in this case, if you think about how they will talk about this case, right? Are the physical evidence based on entry wounds consistent with what the officers say? Well, if you go to stab someone, the portion of your body that is exposed is the left side. That's what is facing an officer, Officer Shesky, who is firing the shots. We'll show you a diagram of where those shots are located on the body. This is, again, the best estimate. Here is Brian Peterson, the doctor, offering that opinion. So you can see those primary entrance wounds are right under that armpit, okay, on the side. 3 of them there. So if the natural reaction of anyone being shot at is after that occurs, you're turning away from the shots, then it would be at least a rational argument by the defense to say that is why there are also shots to the back, right? Because they've moved back. And we know his body comes back to facing the officer in the back because he becomes seated there. Now, we have no way of determining which of those 7 shots come when. So we don't know the order, right? I'm suggesting to you simply that there is a rational, logical scenario that anyone defending this case along for these officers would be able to use this physical evidence I'm describing to be able to persuasively tell a jury This is consistent with what these officers have told you about what occurred. Okay? And you will hear Officer Shesky said, I stopped firing when there was no longer a threat. You'll hear also that Officer Shesky had 10 more bullets in his gun at the point DCI comes across him. So clearly he has not fired to empty all the chambers of his weapon. He stopped volitionally firing that weapon. He indicates why or when he did that. I want to mention one other moment that mattered to me. I don't know if it will to you, but I just thought it has to do with the tremendous difficulties and challenging of modern policing in the era that we're thinking about today. Officer Shesky says that after he finished shooting, that Jacob Blake came to a seated situation. He put his weapon away, immediately tried to determine whether any other weapons were a threat, and then he pulled out Jacob Blake and immediately began life-saving measures on him. And that's also reported by the videographer in this case, who says, as a civilian witness, those officers took him out immediately and began to help him. And here's a moment that I thought mattered because it talks about all the things that we are demanding and expect of officers. Because this is seconds after Jacob Blake, according to Officer Shesky, is moving a weapon to try to stab him, and after Officer Shesky has fired his weapon at Jacob Blake. Shesky says, Blake kept saying on the ground, I'm going to die. And Shesky kept saying to him, you're going to be okay, as they waited for the ambulance. Here's the officer and man who were just in what is what? Kind of mortal conflict, right? And now the officer's role is to be the consoler, to be the person who tries to get him through those grievous injuries. That is the varied, complex conversation that we need to have about law enforcement in America today. Because Officer Shesky seamlessly wore both of those hats at the moment in this incident. Without delay, without pause, he wore both of the hats that we absolutely would want him to wear in that situation. A protector of a domestic abuse situation, and then ultimately a protector and consoler to Jacob Blake. Okay, I mentioned Jacob Blake would be a star witness. Okay? Absolutely necessary witness if anyone was to say that Officer Shesky was going to be charged with criminal behavior. You would absolutely need to put Jacob Blake on the stand, no doubt about it. And so the question would be, are there a lot of things he agrees with the officers on? And there is. He admits he got into an argument with LaQuisha Booker. He admits he wouldn't give back the car keys. He admits he was armed with a knife. He admits he physically struggled with officers. He admits he twice ripped out the taser probes and continued on in not complying with the officers. He admits that he was attempting to get in the driver's seat of the SUV. All of those things that are completely agreed on. It is the areas where officers and Jacob Blake disagree, which would severely compromise any ability to prosecute Officer Shesky. Officer Shesky says this guy had a warrant. All the things he was doing are consistent with arresting in a warrant, we're trying to resisting a warrant. He doesn't want to go to jail. And so I tried to tase him. I did everything I could. I could not get him under control in that situation. Jacob Blake tells DCI, I didn't know why these officers were coming across me. I thought these officers were just trying to beat me. I thought they were harassing me. I had no idea or reason for these officers to do this. They never told me why they were doing this. And so I'm just trying to get to a safe place and away from my kids. So DCI asked Jacob Blake, well, did you know there was a warrant for your arrest? And he said, I did not. I did not know there was a warrant for my arrest. Here's a key point where we can determine credibility. If Jacob Blake is wrong, if he is lying here, he's not going to be credible in any of the rest of what he talks about in this case. And it goes right to his motive, right? Because if he knows he has a warrant, that explains why he won't allow officers to take him into custody, why he won't do any of the things that we would expect. Like in front of your kids, maybe you would just comply. But now we would know if in fact he knew he had a warrant. So here's what we know. In his phone on July 14th, we have a text from him to LaQuisha Booker. This is Jacob Blake mentioning that he has an arrest warrant. This is that May 3rd arrest warrant. Now it's July 14th, and he is talking to her in text, talking about his arrest warrant. He has no warrant for anything else. So that is about this case. Even more important is also in his phone are two searches for the exact case that this warrant case is. They're dated August 7th and August 9th. So on his phone are internet searches, and what this website does, Circuit Court Access, is it tells you whether you have a warrant. One of the things, the major thing it does, if you haven't appeared, which he hadn't done, was it tells you if there's a warrant. So, remember I showed you the text where he is trying to convince LaQuisha to say, I don't remember, and drop charges. Here he is, checking to see if that's occurring. This is just a couple weeks before the shooting. He knows, based on these searches, that there is a warrant for his arrest. Another key question in this case, for this star witness Jacob Blake, at a jury trial, would be what is his intention with this knife? Now this is a huge controversy. Jacob Blake says, I had a knife. I don't remember if it was open or not. I don't think it was open. We know it was open. We found it that way. You've seen the picture. But more importantly, he says, I had no intention in any way of doing anything towards an officer with this knife. I never lunged at an officer. I never twisted my body towards an officer with this knife. The knife had no impact where I was trying to do something with an officer. And so there is a quote from him to DCI. He says to DCI, why would I pull a knife on a cop? What am I, a knife thrower? I ain't going to pull no knife on no damn cop. That's just stupid. Okay? Here's why this is important. Because when he says to DCI, I would never be that guy. I'm not the guy who would ever pull a knife on a cop. Now he is exposed to cross-examination. Remember, if he's going to take the stand, the defense attorneys are going to cross-examine him. And the problem is there's a 2010 case, Cook County Sheriff's Department case, which will be subject to withering cross-examination on Jacob Blake, having made that statement I just described. So here's what would happen. He would be asked on cross-examination, so you say you're an individual who would never pull a knife on an officer. Is that true? Well, isn't there a prior occasion in 2010 where you also resisted officers when they tried to command? And isn't it true that in that case, you also reached into your waistband with your left hand and pulled out a knife? By the way, that's what what the officers say occurred in our case as well. Left hand got the knife out of the waistband. And isn't it true that in that case in 2010, you produced a knife where the blade was open? Remember, in our case, a knife is produced with the blade open. And isn't it true that officers jumped back, they yelled knife, and they drew weapons, and even after those officers in 2010 drew those weapons, you slashed at an officer's chest? And then he'd be asked under cross-examination, isn't it true even after officers pointed weapons at you, you proceeded towards them, saying, come on and shoot me, still swirling that knife around in a threatening manner? And isn't it finally true that you refused repeated commands to drop the knife and were tased multiple times before they took you into custody? Okay? A lot of similarities to our case. Again, it in no way would be able to demonstrate to you folks that he acted in conformity. This is 10 years ago. But he would be subject to absolutely devastating cross-examination that a jury would hear about an incident where he did display a knife, and if he denied any of those things, he would be shown the police reports. If I was cross-examining him, I would present him with the police reports and say, please read this. Are you saying the officer is lying when he reports each of those details? That would be the jury trial that would occur if Officer Chesky was charged and the privilege of self-defense would be in place. Okay, so I've told you about two ways that I think Jacob Blake would be devastated as a witness in a jury trial. And I do that from a professional place. I want to briefly talk about LaQuisha Booker. I've mentioned her by name today, despite the fact that she's an domestic abuse victim in my perception of this case. I do that because after a very initial contact on August 23rd, where she confirmed many of the details of this case, she has been completely unavailable to DCI to try to do any follow-up discussion. So here's a witness who's present directly for almost all of what happened. She's the person who originally made the call to police, and she has not made herself available to DCI. And so really, as a prosecutor, I'm only able to go with the evidence that is available to me, and she has not been available. She also was not available to the special prosecutor on that warrant case. So Walworth County took that case as a special prosecutor. They could not find her. They could not serve her. And so when they resolved their case, they made a record saying, we're not able to find her. A week after, or right after Thanksgiving, we were very close to being at a point where we were going to issue a decision in this case. And DCI received a tip that has some factual discussion or circumstances as to why LaQuisha Booker may not have been available either to DCI or to Walworth law enforcement. And at that time, those things began to be investigated by DCI. And so we wanted to give DCI an opportunity to see if that investigation could be completed. It's still a pending investigation. I'm not going to answer any other questions other than that we have no specific concern that she's unsafe. But I'm indicating to you there is an investigation going on about that. Again, I'm going to refuse to answer any additional questions regarding that. But from my perspective, that's both important because it did delay this case, and also important because it is consistent with the difficulties that a domestic abuse case brings. And she's a witness who any prosecution of an officer would certainly expect to bring. Okay, with that, I want to say finally that Noble Ray is here. I'm going to introduce him in a moment. And I'm just going to ask you to consider finally that ultimately in a self-defense case, what would happen is that the question would happen is what would a reasonable officer do at each of the decision points here? And that's why this neutral, independent use of force expert was so important. And so Noble Ray was employed in this case. Again, I don't think it's ever been done that way before. But he comes with extraordinary qualifications. He has some opinions to offer. And when he's finished, I'm going to briefly conclude. Thank you very much.